I'm Ben Meiselas from the MeidasTouch Network. The 11th Circuit Court of Appeals has officially set an oral argument date in connection with the expedited appeal filed by the Department of Justice regarding their appeal of Judge Eileen Cannon's assertion of equitable jurisdiction following the Department of Justice executing a lawful and valid search warrant on Mar-a-Lago on August 8th. Trump ran to Judge Eileen Cannon. A few weeks later, she asserted equitable jurisdiction, which she never should have in the first place. This is the overall appeal now on Judge Eileen Cannon's assertion of equitable jurisdiction regarding the remaining 11,000 other documents that Donald Trump stole, which are part of the special master process that was initiated based on this improper finding by Cannon of equitable jurisdiction. You will recall that the 11th Circuit Court of Appeals had previously ruled in favor of the Department of Justice when the Department of Justice filed an emergency motion for partial stay to return the 100 classified documents that Donald Trump stole. The Department of Justice said, look, we don't believe Cannon should have had equitable jurisdiction over all of these documents, but we really need these top secret classified records back because Americans are going to get killed if we don't get it back. Our national security interests dictate we need these records back, and we're pursuing a criminal investigation where we're questioning other witnesses, and the 11th Circuit Court of Appeals analyzed these factors, which I'll talk about in a moment, and they found Judge Eileen Cannon should never have asserted equitable jurisdiction regarding those records. Those records were returned to the Department of Justice. Donald Trump tried to appeal that to the United States Supreme Court. The Supreme Court denied the emergency request by Donald Trump to vacate what the 11th Circuit did, so the Department of Justice won there. Now there is this expedited appeal process. The Department of Justice filed a motion to expedite, which the 11th Circuit granted. This is going to be heard before a new three-judge panel, so it's not the previous three-judge panel at the 11th Circuit, which ruled in favor of the Department of Justice, but I'm very confident that this three-judge panel is going to agree with what the other three-judge panel said. And the other three-judge panel reached a per curiam decision, which means it was a unanimous 3-0 position that Donald Trump lost with respect to returning those 100 classified records. And so the Department of Justice had previously filed a motion to expedite the appeal to basically stop Judge Eileen Cannon from staying on this case and removing her from the case, trying to get the 11th Circuit to rule that she should never have asserted equitable jurisdiction in the first place. And the 11th Circuit Court of Appeals had previously set the following briefing schedule. They granted the Department of Justice's motion for an expedited appeal, and they ruled appellant's initial brief, so the DOJ's initial brief, is due on or before October 14th, 2022. So that was filed by the Department of Justice then. Appellee's response brief is due on November 10th, 2022. So Trump had already filed his brief on November 10th, 2022. Appellant's reply brief, if any, is due on November 17th, 2022. So before the DOJ has even filed its reply brief, which is due November 17th, 2022, the 11th Circuit Court of Appeals said, we're ready to hear oral argument. They scheduled it for November 22nd, and I think this is a very good sign. It shows that the 11th Circuit realizes that Judge Eileen Cannon should never have asserted equitable jurisdiction. They realize that there are important national security implications still at stake here. Granted, the 100 classified records were returned to the Department of Justice, but the Department of Justice, the current executive branch, needs its records back. You can't just allow people to steal records and delay. And what I think this ultimately means, and if you've been following the MeidasTouch network, I've been saying this for a long time. I'm like, look, I really like the orders that Judge Raymond Dearie is making, the special master who Trump recommended, who's now ruling against Trump because Trump is completely full of crap. And even at the hearings before Judge Raymond Dearie's like, look, you're not going to use my court to play games here. Where's the beef? Where are the disputes here? You can't steal government records and just divine them and claim they're personal. And Judge Dearie's basically said too, like, submit affidavits and go under penalty of perjury. And Donald Trump's run back to Judge Eileen Cannon, who's so far kind of blocked Trump from submitting affidavits. But Judge Raymond Dearie is no fan of Donald Trump. But the Department of Justice, Judge Cannon shouldn't even be on this case. And I've been saying here on the MeidasTouch network that I believe the 11th Circuit was going to set an oral argument in late November or early December, and that we would see a ruling very soon thereafter from the 11th Circuit, which would basically overturn Judge Eileen Cannon's ruling, where she asserted equitable jurisdiction and started this process that has the special master reviewing the other 11,000 documents. She never had jurisdiction in the first place. And so oral argument to take place November 22nd. We will see the Department of Justice's brief. They will undoubtedly file a very surgical reply brief to Donald Trump's 83-page ranting and raving mess of a brief that Trump filed back on November 10th. You're going to see a surgical takedown by the Department of Justice in this reply brief. We're going to see oral argument. I predict Trump's lawyers are just going to be humiliated at oral argument because all of their arguments are completely in bad faith. And I expect an order now, knowing that oral argument date. I would not be surprised if Judge Eileen Cannon is reversed and this whole special master process ends before December 1. Given the Thanksgiving holiday, it's possible we go into the first week of December. I doubt it goes into the second week of December. I think we'll get a ruling by the 11th Circuit. So why am I so confident that the 11th Circuit is going to rule against Donald Trump here? Well, one, there's basic logic, right? You can't just steal things and then say me, and because I used to be the president, I could just steal government records. So there's that basic level. But on the other level, it is the most rare of circumstances where a judge can assert what's called equitable jurisdiction. In essence, there really isn't a law or statute or anything that says the judge should get involved, right? Like, for a judge to have jurisdiction, the law has to say you can be involved. But for equitable jurisdiction, it basically says that an individual like a Trump who's being investigated, they're being so deprived of all of their rights through the normal process. And it's so egregious that a federal judge just needs to step in and say, look, I know there's no law out there that says I can be involved, but for the purpose of equity, I need to get involved because there's some bad things going down now. And so different circuit courts of appeals in different areas have different tests of what triggers a judge saying equitable jurisdiction. In the 11th Circuit Court of Appeals, which borrowed on precedent from the 5th Circuit when the courts expanded, I won't geek out fully here, but it's a 1975 case that's called the Ritchie case, and it sets forth these standards. And the standards for a judge to exercise equitable jurisdiction are: one, whether the individual being investigated is subject to this callous disregard of their rights by the government entity. So did the DOJ engage in a callous disregard of Trump's rights here? Of course they didn't. They went to a magistrate judge, Judge Reinhardt, on August 5th, who found probable cause, who signed off on a search warrant, the way search warrants are handled all the time, and the search warrant was executed on August 8th after a probable cause finding. Even Judge Eileen Cannon found that there was not a callous disregard of Trump's rights. But then she went on to the other factors. What are the other factors? That the individual being investigated would suffer irreparable harm. And Cannon found Trump would suffer irreparable reputational harm by this process. I'm not making that up. That's actually what Cannon found. And then one of the other factors is the need for the individual being investigated whose documents or property is seized to get these documents back. And she found that he needed to get these documents back. And what the 11th Circuit found in their ruling regarding the 100 classified records is they found the callous disregard test is a threshold inquiry for equitable jurisdiction, meaning if you don't find that the government engaged in a callous disregard, right then and there, your inquiry should end. There is no ability to assert equitable jurisdiction. But in any event, the 11th Circuit then analyzed the other factors, and they said Trump can't suffer irreparable harm. The documents don't belong to him. How would he suffer irreparable harm for documents he stole? And then they said he can't have any need for these documents back. They're not his. They belong to the executive branch. And they said the executive branch, the current executive branch, has a compelling need for it. They are engaged in a criminal investigation with a grand jury. That grand jury is in Washington, D.C., and they need to conduct their criminal investigation. And a court shouldn't intervene and interfere with that. So the 11th Circuit previously ruled for the DOJ under that analysis. But that same analysis applies to the other government records. So I'm extrapolating. If the 11th Circuit found that here, the exact same findings are going to be made with the other documents, the 11,000 other documents that Donald Trump stole there. Now, the other argument that Donald Trump made regarding the previous motion filed by the Department of Justice with the 11th Circuit, which Trump makes again, is he argues the 11th Circuit Court of Appeals does not even have jurisdiction to hear this matter because a court of appeals can only have jurisdiction before a final judgment under something called interlocutory review. You know, is it subject to an interlocutory review by a court of appeals here? And Trump says a decision to appoint the special master is not subject to interlocutory review by a court of appeals. And the court of appeals said, well, you're ignoring the fact that what the special master process sets forth is enjoining. It's an injunction, and it's stopping the Department of Justice from utilizing their own records in a criminal investigation. So whether we're utilizing our interlocutory review on the injunction ruling, because it was an injunction that Cannon ordered, or whether we're exercising pendant jurisdiction, in other words, the underlying order and the special master order are inextricably intertwined such that we do have interlocutory review over the injunction, or whether there's just this is a collateral order jurisdiction. In other words, whether in essence not giving the Department of Justice their records back almost acts as a final judgment and prejudices their rights. And also this is a national security issue. Like, for all of these reasons, we're the 11th Circuit, we can get involved in this. And what are you talking about, Donald Trump? That just because Judge Eileen Cannon wrote a very sloppy order in her appointment of the special master, why that means that we can't get involved as the 11th Circuit Court of Appeals. So the 11th Circuit Court of Appeals already rejected the jurisdictional argument. Trump makes that argument again in his 83-page brief that he filed on November 10th. And as I said, on November 17th, the DOJ is going to file their very surgical brief, and they are going to rebut all those arguments that Trump made. And what are they going to cite? They're going to cite the previous case by the 11th Circuit. The 11th Circuit now has already made the precedent against Trump, which the Department of Justice is going to utilize here in their reply brief. So Trump is going to lose this. It is a great sign that this is scheduled oral argument for November 22nd, because that means I think Judge Eileen Cannon and this whole process will be overruled late November, early December, maybe the second week of December, but we'll get that ruling out soon. Yeah, Trump may try to appeal on an emergency basis to the Supreme Court like he did before. Clarence Thomas oversees the 11th Circuit, but like he did before, Clarence Thomas will likely refer the matter to the full court. They're going to deny it the same way they denied his previous attempt at trying to vacate what the 11th Circuit did. good news for justice right here. This is a real good update. That oral argument scheduled for November 22nd. We'll bring you that oral argument right here on the MeidasTouch Network. Hit the subscribe button right now. We're on our way to 1 million subscribers thanks to your support. And also consider becoming a patron of MeidasTouch by going to patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's a number of subscription memberships there that you can join with exclusive content, but most importantly, wherever you are in the world, you could help grow this independent media platform. We're not funded by any outside investors, so we purely rely on you. Thank you so much. I'm Ben Meiselas from the MeidasTouch Network.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.